Thank you.
Thanks for this presentation. Sorry, I can only put to the PowerPoint. So before starting, I would like also to thank the organizers for this invitation here today. So it's my first time here, and I'm really happy to have this opportunity to share my research in this conference. So as Roberto mentioned, I will focus today on the relationship between constitutional law and collective memory. And in doing this, I will introduce a case study approach. So I will focus on Southeastern Europe. And with this term, Southeastern Europe, I intend basically the Yugoslav successor states, so the states that emerged from the violent dissolution of the former Yugoslavia in the 1990s. These countries, or this region, so Southeastern Europe, is very interesting to study when it comes to collective memory. And this is because these are all post-conflict societies, and post-conflict societies are notoriously very difficult and complex cases when it comes to the construction of collective memory. So today I will focus basically on Croatia, Bosnia and Herzegovina, and Serbia, simply because these three are the most deeply involved. This country was the countries which were very deeply involved in the conflict of the 1990s. However, I will also say something, so I will also refer to other countries of the region. So the aim of my presentation is to show some challenges of memory making in post-conflict societies, so in post-conflict settings. And so basically, I will try to show how memory can be manipulated and instrumentalized through law in order not to help the reconciliation or democratization of societies, but on the contrary, to reinforce and to create divisions, regimes of exclusions, and the renewal of ethnic tensions. So basically, what we will see from my presentations are only how it works when we have the abuses of memory through legislation. Sorry. Okay. The current memory landscape in the region is very fragmented and contested. And this is because what is happening here today is that we have these same historical events, but they all receive multiple and competing interpretations. And we can find these multiple and competing interpretations, in particular of traumatic historical events, such as, for example, the armed conflict of the 1990s. Then we can find these competing interpretations in relation to the legacies of communism, and in particular to the legacies of former Yugoslavia, and in relation to the Second World War, which was particularly brutal in this region. So the result of these competing interpretations is this creation of a divisive and conflicting memories, both within and between states. So these divisive memories started to emerge in the region at the beginning of the 1990s, I would say even before the war started in the 1990s. And so what we had in that period was the rise of ethno-nationalist interpretations of the past. So we had the rise of ethno-nationalism, and with the rise of ethno-nationalism, we had these ethno-nationalist interpretations of the past. And when ethno-nationalism is dealing with the past, it usually creates mythical narratives. It usually creates myths about national past. So when you're speaking about these founding myths that ethno-nationalism creates, we are speaking basically about invented tradition or fictitious narratives which are perceived sacred for the nation. So the aim of this myth-making of the early 1990s was to create new national identities and also to legitimize the emergence of new nation state from the violent dissolution of the former Yugoslavia. So the myth-making was really an official state policy. It also replaced official history, and according to scholars, it was not a direct cause of the wars of the 1990s, but it was for sure the driver of violence. And this is why the Yugoslav wars of the 1990s are very often called as wars of myths. So more than 30 years after the Yugoslav wars, memory politics is still used to reinforce these nationalist interpretations of the past, so these founding myths created under the rise of nationalism, so the myths that led to this violent conflict, to the extent that some scholars have observed that the previous ethnic conflict did not finish. It has only been transferred to the fields of history and memory. So since the beginning of the 1990s, these founding myths, so these memory narratives started to be also incorporated in a series of legal documents, including constitutions, legislation, resolutions, and declarations, so hard and soft memory laws. So from these documents, we can extrapolate today three foundational narratives, which basically are positioned at the basis of national identity in Southeastern Europe. And the first of these narratives is given by the myths about the origins and continuity of nationhood and statehood. The second narratives are given by the myths about the Second World War. And finally, we have a narrative, the third narrative, which is given by the myths about the Yugoslav wars of the 1990s. So what is common to these three types of narratives is that they are all ethnocentric, mutually exclusive, divisive, and intolerant. So for the rest of my presentation, I will try to explain the meaning of these narratives, and then I will also try to show how they were incorporated in legal documents. So I will start with the myths of origins and continuity. So these narratives usually anchor the origins of the state and the nation to very distant and often medieval past. So the history usually of the nation starts, according to these narratives, in the Middle Ages. And also there is this claim of this uninterrupted continuity between medieval states formation and present-day states. These narratives are backdating history, obviously, for hundreds of years, because the modern nationhood is a recent phenomenon, so from the 19th century. However, these are narratives that we can find in the region in almost all constitutions, and in particular in constitutional preambles. And the main example of this is given by the Constitution of Croatia of the 1990s. So it has been adopted even before the country proclaimed the independence from the former Yugoslavia. And let's say also that this type of narratives also prepared the country for the declaration of independence. So the Constitution opens with the preamble, which is called Historical Foundations, and the preamble proclaims the millennial nationhood and statehood of Croatian nation, and it expressly states that the starting point of this millennial nationhood and statehood is given by the arrival of the Croats in the 7th century on their lands, when they built the so-called Croatian principalities, which were then replaced by an independent medieval kingdom in the 10th century. And the preamble also stated that there is an unbroken continuity between the 7th century and present-day state, so modern Croatia. And it even lists a series of historical state formations and historical decisions as a proof of this continuity. And all the history which is proclaimed in the preamble, which are basically invented traditions, is called as historical truth. So these are not only symbolic provisions, because they are held together by a legal principle, which is called historical state right. So the concept of historical state, so right emerged in the 19th century. It forms a foundational doctrine of Croatian nationalism. We can find it also in other countries of Central and Eastern Europe. But however, in Croatia, it has been developed as a legal concept in the 19th century, and it has been then revived by the Constitution of the 1990, because the Constitution, so the preamble, states expressly, so identifies the historical state right as a source of sovereignty of Croatian nation. So the core claims of these principles are first of all, this continuity of Croatian statehood since the early Middle Ages, since the 7th century, and this continuity between the 7th century and today Croatia. And this principle basically asserts that there was a survival of Croatian statehood even in periods in which the Croatian lands were incorporated into larger states, such as, for example, the Austrian Empire or Yugoslavia. It also affirms the territorial integrity of historically Croatian lands, and this is very interesting because, as you can see, it considers historically Russian lands the lands of the Kingdom of Croatia of 11th century. Why? Simply because this was the period in which the medieval kingdom reached the moment of maximum expansion. And according to this principle, Croats are the sole nation entitled to sovereignty over these historical lands by virtue of primary acquisition. So it means that we came first here, this is our land. The incorporation of such principles in the Constitution is alarming, because such narratives support ideas of greater nation, and they also justify territorial claims. And in fact, in the wars of the 1990s, Croatia tried to recreate the borders of the medieval kingdom. Serbia tried to do the same, and we had with Bosnia and Herzegovina, which became the theater of the conflict. Why? Because, as you can see here, the borders of the medieval kingdom of Croatia entered in Bosnia and Herzegovina, and on the other hand, also this happened also with the Serbian narrative. So the medieval Serbian kingdom also entered into the Bosnia and Herzegovina, and this is why the theater of the conflict became Bosnia and Herzegovina. And what we can see here with this recalling of historical states lands is very similar to what is happening today also in the Russia-Ukraine war, which we can discuss also later further during the Q&A session. Okay, so in the Constitution, the aim of this incorporation of this medieval past is to construct ethnic primacy through invented traditions. So as you can see, so this is, we have here a constitutionalization of an ethnic past. So a past that glorifies only one group, that is the majority nation, in the case of Croatia, the Croatian nation, and it totally marginalized others. So there is no space for introduction or inclusion of collective memories of minority groups. So minority groups are not recognized as a community with a shared past. And there is also a specific purpose of this. The purpose of the introduction of this medieval past in the Constitution is to define the state and the nation in terms of ethnicity. And in fact, the second part of the preamble of the Croatian Constitution established that the Republic of Croatia is first and foremost the state of the Croatian nation, and only in the second instance it is also a state of members of other national minorities. So basically these provisions affirms the supremacy of the dominant nation, so of the titular nation, of the dominant Croatian nation, who is the only nation which is entitled to statehood and sovereignty, and they also positions other ethnic minorities in an unequal position. So other ethnic minorities are considered in the preamble as second-class citizens. So this creates something that I call a hierarchy of belonging. So because basically the Constitution classifies the population in three categories. So we have the dominant nation, which is the owner of the state. Then we have the members of expressly listed national minorities, so which are people with equal rights, but not but they are not the primary bearers to the right to the state. And then we have also the others, which are the members of ethnic minorities that are not even mentioned by name in the Constitution. So this was the case of the original text of the Constitution. There was an intervention by the European Union when Croatia had to adopt and adapt the Constitution to the European Union accession, asking basically to eliminate this ethnic principle included in the Constitution. So today, the only category that has been eliminated by this Euro amendment in 2010 is the category of others. So instead of establishing in the preamble that Croatia is a state of all of its citizens, still the preamble distinguished between the dominant nation, who is the owner of the state, but now we have the mentioning the list of 22 national minorities in the preamble. So this is why the category of the others has been excluded. So in other constitutions of the region, we find similar references to the Middle Ages, so to this medieval past, and we can find these references usually in the preambles, which are recalling this centuries-old past or centuries-long struggle for independence. This is the case of the Constitution of Slovenia. This is the case also of the Constitution of North Macedonia, at least until 2001. So the purpose is always the same. The purpose of this provision of introducing this ethnic past in the Constitution is to define the nation in ethnic terms, and also to establish that the state belongs primarily to the titular nation, for example, to the Slovenes, to North Macedonians, and so on. Also here, such provision, the inclusions of such provision in Constitution is alarming because during the wars of the 90s, this is how basically the war started in the 1990s. So, for example, in Croatia, during the socialist period, Serbs were considered as a constituent nation, and in North Macedonia, Albanians were considered as a constituent nation. Then, with the adoption of new constitutions in the 1990s and with the Declaration of Independence, basically Serbs were excluded, so were transformed in the constitution, so into a national minority. So from the constituent nation, they became a national minority. And the same happened with Albanians in the constitution of North Macedonia, and this really contributed to the outbreak of the conflict of the 1990s and in North Macedonia in early 2000s. So we saw before how this has been solved in the Croatian constitution, which basically inserted the list of national minorities in the preamble, and the situation, this discriminatory situation has been solved also, at least partially in North Macedonia, only with the Ohrid Framework Agreement, after which has been concluded after the conflict. But still, despite these reforms, there is still the primacy of the dominant nation. So the primacy of the dominant nation persists in this constitution. So it is still an ongoing issue. Okay, so from the constitutional level to the legislation, the situation is more or less the same. So when it comes to the myths about the Second World War, so the narrative here is that there is basically a strong condemnation of socialist Yugoslavia, and at the same time there is rehabilitation of past fascist movements and Nazi collaborators, such as the Ustaša in Croatia, Chetniks in Serbia, and Domobranci in Slovenia. And also the narrative is diminishing national crimes committed in the Holocaust. So the myths about the Second World War are very similar to the ones that have been created in Central and Eastern Europe. However, here I think that they were created before the one that emerged in Central and Eastern Europe, and are included today in a series of so-called rehabilitation laws. Also here, again, the first country to elaborate the myth about the Second World War, so basically World War II revisionism, was Croatia. So immediately in the early 1990s, he started to rehabilitate the independent state of Croatia, which was basically a Nazi puppet state led by the fascist Ustasha movement. So it was not really independent. So it was recognized as an independent state only by Germany and Italy. But as of the early 1990s, this state is presented not only as a fascist crime, but also as an expression of the historical dream of the Croatian nation for its own independent state. So the rehabilitation occurred through two laws: the law on pension and disability insurance of 1993, which grants pensions to former Ustasha members, and for which Croatia sets aside 45 million euros annually. And then we have the second law on holidays, memorial days, and non-working days. This law introduced the so-called Day of Remembrance for Croatian victims in the struggle for freedom and independence, which is commemorated on May 15. So basically, this day commemorates events at Bleiburg. So Bleiburg is a small municipality in Austria at the border with Slovenia. In 1945, partisan forces have killed some people here who were members of Ustasha and basically their families. The number of the people is still unknown, and it was really a crime. However, this legislation is problematic because it does not distinguish between civilians and Nazi and fascist collaborating forces, and it presents basically the members of the Ustasha movement as innocent victims of communism. So the situation, okay, so this also, this type of narrative allows also basically the public display of the Ustasha symbols in the country. So, for example, in 2011, as part of the European Union integration process, Croatia adopted the amendments to the Croatian Criminal Code. And with these amendments, the country criminalized the denial of international crimes. However, and it was made on purpose, this legislation did not define the very nature of the independent state of Croatia, or the nature of the Ustasha ideology. And this created this legal gap, and so this is why it makes possible basically today the integration of the Ustasha symbols into the emblems of legally registered association. So what you can see on these pictures is a family wearing Ustasha uniforms during the annual Bleiburg commemoration. So the picture is from several years. It's several years old, because today this is not possible anymore, because Austria banned the display of the Ustasha symbols, while Croatia is still failing to do the same. So similar is the narrative about the Second World War exists also in Serbia. It has been included in the rehabilitation law of 2006. Similarly, also here, this legislation portrays Chetniks not as Nazi collaborators, but as anti-communist resistors to the Nazi regime. And the key outcome of this legislation was the 2015 rehabilitation of the Chetnik leader, Dragoljub Mihailović, by the Belgrade Higher Court, which basically annulled the 1946 communist era death verdict. Then we have also the law on war memorials, which is more recent, and which basically prohibits the construction of monuments dedicated to figures representing fascist or Nazi ideology, but excludes individuals already rehabilitated or under rehabilitation proceedings. And this basically means that you can build all around Serbia monuments to convicted World War II criminals. Okay, so the last foundational narrative which has been inserted in the legislation is given by the myths about the Yugoslav wars of the 1990s. But what should be mentioned is that basically these wars, so the Yugoslav wars of the 1990s, are seen in the narrative as a continuation of the Second World War, and they should be read in this way. So when it comes to the narratives about the Yugoslav wars of the 1990s, in all states they are depicted as homeland, patriotic, defensive, or liberation wars. So there is this strong emphasis on the defensive character of the war. So basically, what these narratives are promoting is a vision of the war in which you don't have the aggressor. There is no aggressor. We have only victims. So also here, again, Croatia was the first country to elaborate this narrative. And it started by calling the armed conflict on its territory a homeland war. So this is the official name of the wars of the 1990s in Croatia, and it has been called homeland war to emphasize this defensive character. And also the name of defenders was introduced for calling the Croatian soldiers, again for reinforcing the defensive character of this war. So the first time that the homeland war was has been inserted in a legal document was in 1996 when we had a constitutional reform which introduced in the preamble of the Constitution a reference to the homeland war, but however it did not also introduce any definition of a homeland war, because the definition came only later with two declarations. So the Declaration of Homeland War of 2000 and the Declaration on Operation Storm of 2006. Both are very problematic. So the first one describes the conflict of the 1990s as just, legitimate, defensive, and liberating. So basically it portrays Croatia as defending its territory against the Greater Serbia aggression and only within internationally recognized borders. And it also binds state bodies to protect the fundamental values and the dignity of the homeland war. So this declaration, so this narrative inserted in this declaration omits some important crucial events. So it does not mention the civilian victims of the war. It does not mention the exodus of approximately 300,000 Serbs at the end of the war. It does not mention the Croatia's role in the Bosnian War, which resulted in the creation of a new autonomous region called Herceg Bosna with annexation intentions in the name of the historical state right. And also it is problematic because it portrays the war as the sole means of resolving political problem, because the declaration does not mention the other events which were very important on Croatia's path to independence, such as the multi-party elections or the referendum on independence. So the other declaration, the Declaration of Operation Storm. So the term Operation Storm basically is the name of an operation that resulted in the liberation of the vast majority of the occupied territories during the war. So this operation is framed by a declaration as a legitimate, victorious, and internationally legally legitimate action. It constructs a heroic image of the soldiers who respect the customs of war. It acknowledges also that some crimes occurred during the war, but it fails to attribute any responsibility for those crimes, and describes also the relationship of Croatia with Bosnia as cooperative, totally ignoring the Croat-Bosnia conflict. And it also implies that the research on the homeland war can be free as long as it aligns with the state-approved interpretation. So these declarations were adopted as of 2000 for what were in that moment present political needs. So they were basically adopted as a response to the ICTY's indictments of some Croatian generals, which described the Operation Storm as a joint criminal enterprise and the project of ethnic cleansing. So the idea was to define the homeland war as a defensive war and the Operation Storm as a legitimate operation, because this implied this belief that war crimes could not occur in a defensive war. So this idea of Yugoslav wars of the 1990s as a homeland war, as a legitimate war, as a defensive war, was so appealing that Serbia and Republika Srpska, which is one of the two entities of Bosnia and Herzegovina, also adopted this narrative. So in Croatia, it has been also, the same narrative has been elevated at the constitutional level with the 2010 reform, but while in Serbia and Republika Srpska, the narrative is still contained only in the legislation. So in Serbia, the narrative of the Yugoslav wars of the 1990s forms part of this broader narrative about these liberation wars. So this narrative emerged in the 1990s, but has become more relevant only in 2012. And basically, this narrative implies that all wars fought by Serbian armed forces are liberation wars, and also, as in the case of Croatia, the narrative emphasized the heroic and defensive aspects of the war. So, for example, the war in Croatia is depicted in this narrative, and especially the Operation Storm, as an aggression on the Serb minority in Croatia. The Kosovo War, so the narrative about the Kosovo War underlines only the immigration of the 250,000 Serbs from Kosovo, and the NATO bombing underlines only the civilian victims. So in this narrative, the Serbian forces are also depicted, as in the case of Croatia, as fighters for the liberation. And obviously the narrative leaves out the broader context of the war and its dark episodes, such as, for example, the responsibility for the war crimes and the genocide committed during the 1990s. And this narrative has been incorporated in three legal acts. The first one is the Declaration of Srebrenica of 2010. It has been adopted by Serbia as a formal apology for the 1995 genocide, and it has been adopted only to meet the expectations of the European Union for the integration process. However, the declaration does not recognize that the mass killings that occurred in Srebrenica, committed in Srebrenica, constituted the crime of genocide. And in this way, basically, the declaration undermines the ruling of the ICTY and the International Court of Justice, which basically ruled that what happened at the massacre of 8,000 Bosniak men and boys in Srebrenica constituted an act of genocide. So then, in line with this narrative, we had the 2016 amendments to Serbia's criminal code, which penalized the denial of international crimes, but only those adjudicated as such by Serbian courts and the International Criminal Court. And as you can see, here is the law intentionally excludes the rulings of the ICTY and the International Court of Justice, which had adjudicated Srebrenica as a genocide. So basically, this type of legislation legitimizes the denial of the genocide in Serbia. And then we have finally the law on war memorials of 2018, which basically allows the construction of monuments that commemorate Serbia's traditions of liberation wars. And this basically means that in Serbia, you can build monuments also to the convicted war criminals from the last war. Similar legislation exists also in the Republika Srpska, so in one of the entities of Bosnia and Herzegovina. It has been adopted in 2011, so it is a law on monuments and memorials to liberation wars. Also here, the war in Republika Srpska, the war in Bosnia, is called as a homeland war for Republika Srpska. So this homeland war for Republika Srpska is depicted in the law as a liberation war, in order to deny any responsibilities of Bosnian Serbs in the crimes committed in the 1990s. And finally, according to this legislation, only the majority ethnic group is allowed to construct war memorials in the entity, and so this is leading to systemic discrimination against monuments which can be dedicated to minority ethnic groups. Then we have a specific situation in the Brčko district in Bosnia, with the legislation adopted in 2003 that establishes that only monuments based on the equality of all constituent peoples, so Serbs, Croats, and Bosniak, may be erected in public spaces. And then you have here the example. We have here 3 large monuments dedicated. The first one to the army of Bosnia and Herzegovina, so to the Bosniak army. The second one to the Croats, so the Bosnian Croats, so to their army, and the third one to the Bosnian Serbs army. So we have these 3 monuments basically professing mutually irreconcilable views about the 1990s war, and they are basically positioned all in the city center in relative proximity. So this type of memory making, and especially in relation to the Yugoslav wars of the 1990s, led to an official memory politics, which basically denies in these states the crimes that have been committed in the 1990s wars, and also glorifies war criminals. So I will finish here, but we'll give you only some examples. So here, what can you see in this picture is a mural to the convicted war criminal Ratko Mladic in Belgrade in 2021. So some citizens tried to erase the mural, and Serbia sent the police to protect the mural, basically dedicated to Ratko Mladic, who has been convicted for the Srebrenica genocide. We have here another example. This is a commemoration of convicted war criminal Slobodan Praljak in Zagreb in 2017, who is called in this picture as a hero. So he killed himself after receiving the verdict at the court. However, his figure is, so he's perceived as a hero in the country. And finally, we have here an example of what has been called triumphalism. So in the first picture, there is what is written is knife wire Srebrenica, and in the second picture, what is written is that basically the genocide will be repeated, and this is an example of triumphalism, which means that especially in Republika Srpska and Serbia, the genocide is not denied anymore, but today it is also glorified and celebrated. So what does it mean for constitutionalism? I think that at least for these examples, we have to rethink constitutionalism as a memory project. So we have, in order to have the type of constitutionalism that can accommodate collective memory without becoming collective memory an instrument of exclusion, and the possible directions, at least in relation to Southeastern Europe, are to, first of all, pluralize memory, so recognize multiple narratives within constitutional discourse, then separating citizenship from ethnicity, and also strengthening the judicial and institutional safeguards for inclusion, with the aim, obviously, to have a collective memory that does not undermine democratic principles. So thank you. I will stop here. Thank you very much for your attention.
Thank you, Dr. Pistan, and your presentation was really rich, and I think there are several aspects and dimensions that I think it's good to recall. This idea of the relationship between myth making and national identity, but also what role the preambles play in the Mnemonic Constitutionalism. I think it's also really important, and how this pattern of Mnemonic Constitutionalism are unfolding in Southeastern Europe, also through these kind of rehabilitation laws, and also for the brilliant insight at the end of your presentation. So I think that now we are ready to open the floor for the questions. So I have the microphone.
A very brief question. Like in Hungary, for example, there are not many instances that the Constitutional Court directly referred to something about this extreme symbolism and crowns of St. Stephen's and preambles, but they do refer to the concept of historic constitution, which is in itself quite peculiar, I would say, for this medieval apprehension, symbolism and ritualism in Hungarian constitutionalism. It looks like Croatia is a really good competitor for Hungary in terms of populating preambles and real text, but with true mnemonic constitutionalism comme il faut, so within the text, within the confines of the constitution. But do you aware of any constitutional tribunal decision in Croatia where it was actually operationalized in some way, even en passant, like the court really refers to the historical parts of the preamble, or that remains more symbolic in terms of operationalization until now? Thanks.
Thank you very much for the question. There is only one decision, and it has been used for constructing the constitutional identity. So the case was about the dual rights, dual vote rights. So it's not really important. But the court used the preamble and more specifically the past, which has been inserted in the preamble, and also the statement of who is the owner of the state, in order to establish that together with the Article 1st of the Constitution, which basically proclaims a civic state, are forming the constitutional identity of the state. So there is this decision, and this is the only one that I know that in which basically this type of past has been mentioned. I have previously also criticized this decision because basically from here the court established that Croatia is a civic state, and that, I mean, we have clearly an ethnic constitution. It is true that it is inserted this past in the preamble, and this division between the dominant nation and the national minorities are contained in the preamble. But however, they have a clear impact also on other constitutional provisions. So yeah, especially when it comes to the minority rights. Yeah, they also the first article of the Constitution also, yes, established this civic state, but it also speaks about a national equality, which is not really a clear concept, because I have interpreted it as the equality of the dominant nation, not the equality of the whole. So yeah, the medieval past has been used only in relation to this mentioning of the preamble as part of the constitutional identity. But there are some other parts of the preamble that I didn't mention. So there is an anti-fascist tradition in the preamble. It has been really mentioned. But my problem with the Croatian constitution is then you have in the normative part of the constitution symbols which are in continuity with the previous independent state of Croatia, which was yes. So there is this. On the one hand, you have this anti-fascist tradition which has been inserted, but then you have also this continuity. So I find it very problematic. But the anti-fascist tradition has been used in at least 2 cases when the Constitutional Court tried to ban the public display of the Ustasha symbols, and especially the salute for the homeland ready. But however, then the government a few years ago established a council for dealing with the consequences of the authoritarian regimes. And this council basically states that yes, the public display of the Ustasha symbols is unconstitutional, but it is not unconstitutional when it comes to commemorations of the Homeland War, because basically soldiers in the Homeland War were recalling the memory of the Ustasha in that war. So when it comes to that memory, so in that case, you can display also the symbols. When you refer to the Yugoslav wars of the 1990s, you can display also these symbols. So the court really tried to use this anti-fascist tradition, which is in the preamble, to ban this public display, but they are still tolerated. So these are the only two cases that I know. Then Bosnia-Herzegovina is another case because the court was more focused on the symbols, on declaring the unconstitutionality of some symbols that have been adopted as state symbols. So yeah, but the use of medieval past so there are no other decisions for this.
Thank you. Thank you, Carna, for your presentation. Very interesting. I have a question. Did these narratives, claims, constitutionally entrenched claims surface during the pre-accession negotiations of Croatia, for instance, to the European Union, or are they surfacing with regard to Serbia right now, with regard to the Western Balkan enlargement?
Yeah, thanks for the question. So yeah, in 2010, Croatia adopted a series of amendments to the constitution, and one of these was related to the preamble, and this was a request by the European Union. So they basically asked to change the part of the preamble in which the country established the own. So the problem was that the first version of the preamble did not mention all national minorities, but only some, calling the other minorities as others. So the European Union asked to remove somehow this ethnic principle from the preamble, and so what happened is that the other national minorities were added to the previous list, to the first list. So today you have the proclamation of Croatia is a state of a Croatian nation and of these national minorities, and 22 are listed in the preamble. So this is why I previously said it was easier to say Croatia is a state of its citizens between this distinction. And this is why also, despite the European Union asked to change the preamble, still the preamble has this dominance, the prevalence of the dominant nation. When it comes to Serbia, in the same moment, what happened? So they introduced the names of the national minorities, but the same reform introduced in the preamble the narrative about the homeland war. So the narrative in which the homeland war is legitimate, defensive, and so on and so on. And this narrative in Croatia is extremely divisive, because for Croats is positioned really on the basis of their identity, but Serbs will never identify. So the Serb community will never identify with this narrative. So because they saw the homeland war as an operation of ethnic cleansing. So what I thought that basically international organizations or also the European Union don't really know what these countries are inserting in the constitution because they are creating really divisive narratives when the European Union asks for a more reconciliatory preamble. So it's, but for example, in Serbia, there was this, the discourse is based around the Srebrenica genocide, which has not been recognized by the country, at least as a genocide. And the European Union obviously is asking Serbia to adopt a declaration, especially after Montenegro did it, to adopt a declaration in which it acknowledges that Srebrenica was a genocide. But this will be the red line, so Serbia will never accept this. So probably the European Union integration process will block here. So which opens also the topic of the mnemonic conditionality within the European Union. So are these really criteria for the acceptance? So
hi. Oh, yeah, I'm below the screen. Okay. And I just wanted to ask, with regard to the last slide and your conclusions, wouldn't separating citizenship from ethnicity somehow promote a backlash of pan-Yugoslav or Yugoslav views, and at the same time nullify the political narrative that the Balkan states have built in the last 30 years?
Yeah, this is a very interesting question, and this is why they're not doing it. This is why they're not doing it. So basically, so everything is based on this ethnic principle because, because it was this ethnic principle was the main so in the nation building. So the relevance was given to the ethnic principle instead of the civic principle, which existed before. It will be in these cases very difficult to distinguish it, but it is necessary. And also, so Ulad also before mentioned the Citizenship Act. I think that really they should start from the Citizenship Act because this type of divisions and this prevalence of the ethnic principle is contained also in the Citizenship Acts in the region. So I think that maybe starting from there should be at least the first step, could be the first step.
I have a question also connected to also what Professor Delledonne asked before, a question about this kind of looking at the mnemonic constitutionalism through European integration. So from today's presentation we can see that Central Europe is its memory is built on this kind of remembrance of Holocaust, but like on the other side we have of course different signs of memory in Eastern and Southeastern Europe. So how is it possible, and if it's possible, to reconcile these two kind of sides of memory? Because the European Parliament kind of tried to reconcile with the resolution 2009 when Nazis and communists are on the same level. So, and also if it's possible to impose this kind of memory at the supranational level, or memory should be in this sense more kind of I mean, if the European Union is apt to adopt this kind of narratives and to reconcile all of these different part of memories.
I think that the construction of European memory, and I think all will agree, it's very difficult because you have the Western Europe in which the Holocaust is the primary. So, and then you have this Eastern Europe that has this experience of dual totalitarianisms, and this is also why the construction of memory is more difficult there. Yes, the European Parliament tried to quoted Soviet communism with Nazism, and but my problem in this construction of the European memory is that I think that other historical events should be taken more positive, because this type of memory and the European identity, if from this type of memory, is constructed on negative aspects, against communism, against the Holocaust, against Nazism. So I think that today, so the European Union has its own story. So maybe some other narratives can be taken more unitary for the creation of a new narrative of the European Union, such as, for example, the democratic transitions of the 1990s. So I think that maybe historical events that are more unifying and less negative should be taken and for trying to construct a common memory.
Thank you. And okay. Online, I think I don't see. No, there is. Oh, okay. Okay. Okay.
Good evening. Can you hear me?
Yeah.
Can you hear me? Okay, I'm sorry I cannot put my camera on since I have very bad connection. I'm sorry I cannot participate in person. I'm in Barcelona for visiting. I'm Lorenzo De Carlo, PhD student in constitutional law. I'd like, first of all, to thank you for all your brilliant brilliant expositions. My question is about a peculiar case, which is Kosovo. In the Kosovo case, we have the constitution that recognizes the existence of both a Serbian of the Kosovan and Serbian community. There are some specific provisions that safeguard the Serbian community inside Kosovo, but as we know, a great part of the Serbian, if not let's say that an important part of a significant, consistent part of Serbian population, except especially the most nationalist one, refuses the existence of Kosovo as a state. And now my question is, what happens in states like this, where there's a minority that is officially recognized, but at least partially refuses to be identified with the national legal order that proclaims its separateness from the main legal order, from the main community. There can be from maybe a sort of dilemma. From one side, the necessity to get their rights recognized internally, and from the other side, at least a part of the community asks for unification with Serbia, a unification that is clearly not accepted by the whole Kosovo population. Thank you.
Okay, thanks for the question. So I didn't mention the Constitution of Kosovo because the Constitution of Kosovo is formally, it is really a civic constitution. So it is not guided by the ethnic principle, and this happened probably also because it has been adopted only later. Similar is also the Constitution of Montenegro, but for other, which is also guided by the civic principle of the. When I'm speaking about the civic principle, I think here about the civic concept of the nation. This could be in the Kosovo Constitution, I believe, truly a unifying potential. The problem with the Constitution of Kosovo is given by the fact that only Albanians voted for this constitution, and so the Serb community did not vote for it. They left the session when the constitution was adopted, so this will never be a constitution of the whole nation, which is intended in the so Serbs will never identify in this constitution, and I think that this is a primary problem of the Kosovo constitution. There is another thing. So the Constitution of the Republic of Serbia opens also with a preamble in which it basically recalls Kosovo I don't know how many times, but it's an obsessive recalling of Kosovo. And in my previous work, I have my hypothesis is that with this, the Kosovo myth has been inserted in the constitution, and the Kosovo myth is a myth about a battle that occurred in the Middle Ages in the 14th century, and this myth is really position and the basis of the national identity of the Serbs, and it is very difficult to change it. So as I see it, for me, it's at least currently is impossible that the Serb community accept Kosovo as an independent state and that constitution for which they didn't vote. So I don't know if I.
Yeah, thank you. Thank you so much.
Actually, a general one. in the sense that it could be to you, and maybe it's also better if I ask a general question that you and Ulad Belavusau could reply to conclude, if I'm the last person asking today questions, to conclude the seminar. So how then can we, because you also mentioned, you know, like when we were speaking about the European memory and like to try to pick and choose which are the best, best features to keep. How can we choose the best features? Who is going to choose the best features, in the sense that when we speak about mnemonic constitutionalism and the use of memory, it's mostly common to speak about it in the negative sense of it, in the sense of something that is exclusive, something that it's gonna exclude something else. But then how, where is the limit, and who is gonna put the limit to choose what is positive and what is negative to keep, especially nowadays in which, you know, like the world and the each state is becoming every day more multi-ethnic. So of course there is globalization, and states of course wants to keep their own culture. So how is it possible to keep its own culture in a constitution that helps to protect the culture without then abusing it, without using memory in a negative aspect? So how to choose, where's the limit, and how to choose what is a good memory to keep and what is a negative memory to keep? You?
Maybe I'll just answer from here, then I'll return the micro. My honest question is, I don't know, I never thought about this in this dimension, but you're clearly pointing to the central, perhaps, problem with memory regulation in general, is that who is to decide, and we inevitably, there is no such thing ultimately as good and bad, because if collective memory in this Halbach sense that was referred at the beginning of the presentation by Professor Delledonne is about social memory and not about personal memory, inevitably social memory will be in the opposition to personal memory, because our grandparents are telling us ultimately different stories from the grandparents of our friends. And that happens not necessarily between diverse minorities within a multi-ethnic state, but even within a mono-ethnic state. You know, there could be absolutely two versions on political regime, historical past, and you know, the way things are remembered. And perhaps the answer to this is more pluralism. But again, I'm afraid of answering with that pluralism is a panacea, because, as we've also established in the first panel, it's also the illusion that we can get rid of any regulation and make it, you know, absolute free market of historical ideas, because at a certain point we need to have an agreement or disagreement on how to teach history, on how to name streets, etc., etc. But I do think that in the epoch of antagonisms and disagreements, avoiding certain polarizing historical discussions in the public space might be healthier, to put a certain, not in oblivion, not as a sort of damnatio memoria, not as a sort of putting everything under the carpet. But, you know, sometimes emotions are also the evil of the genuine discussion, reconstruction of historical truth, which is factology and which is pregnant with emotions and the stories of our grandparents again. But in order to dissect them, sometimes we need to dissect them with a cold mind. So that's perhaps the best I can answer. Thanks.
Yeah, I mean, I truly believe in the reconciliatory potential of memory. I think that the Constitution of South Africa is one of these examples. At least at the level of constitutional provisions on how to have a constitution with reconciliatory potential by using memory. I also think about the unitary potential of memory. So, and here I'm thinking also about the U.S. Constitution. So it was exclusionary in the beginning, but then we had this constitutional amendments procedure, which basically corrected the original failure of the Constitution. And for this reason, they have been called as a counter monument. Because yes, they corrected this original failure. So the fact that the Constitution was not inclusive, and I think also that there are other constitutions in the world that have this more that inserted a more reconciliatory potential. So for me, what should be excluded, at least from constitutions and legislation, but it is probably impossible, are these founding myths which have been created by nationalism. So this is something that you simply do not put in the constitution. So also because in this way, so the collective memory can be changed. So it is a process. So what is a position today at the basis of our national identity will not be tomorrow, probably, because these narratives about the identity can change. But if you insert this in the constitution, basically you prevent this, because you need a constitutional amendment procedure or however, so to change them. So memory became more rigid because it is in the constitution. So this is what I think that should be avoided. So this type of founding myths, which is, I think that they are not really a risk in Western Europe, because in Western Europe, and Ulad here will probably agree because he wrote about it. So in Western Europe, memories have been democratized, desacralized. But on the other hand, we have still Eastern Europe in which there is this need of founding myths, and probably the mistake is the inclusion of these myths at the constitutional level, because if you include them there will be very difficult to change over the time. So yeah, this would be what I think.
Thank you, and I think now I will leave also the floor to Professor Delledonne for the concluding remarks.
Even better. So again, I would like to express my gratitude to our guests, those who have spoken today. I'm very sorry, and I have received a request from Professor Barbara Henry, who has told me she's very sorry not to be able to be with us this afternoon, but thank you to Ulad, to Giuseppe, to Carna, and of course to the driving forces behind the organization of this conference, Roberto and Rebecca, and all the other doctoral students who have contributed to the debate this afternoon. I think we have learned a lot. And we were discussing with Carna during the coffee break point. So we tend, for a number of reasons, to emphasize the divide between the older and the new member states in the European Union. Well, we have also focused on Russia and other cases, but mostly on member states or candidate countries of the European Union. I think that what has emerged from the presentation this afternoon is also that, in spite of the obvious differences, there is also the recurring presence of similar problems and similar challenges throughout what Armin von Bogdandy has called the European legal space. And let's say there is also the troubling subsequent step, that is the link between mnemonic constitutionalism, the constitutional mobilization of mnemonic topics, mnemonic arguments, and processes of constitutional decay, and I think this will stay with us for a while, so for better or for worse. So again, I don't want to be overly pessimistic, so I prefer to thank you again for your participation this afternoon, and have a nice evening and a nice weekend. Thank you.
Thank you. Thank you.
Thank you.
See you.